Now we're going to turn to another aspect of business law having to do with debtor-creditor relationships. A creditor is a person who extends any kind of credit or loan, and therefore a debt is owed to the creditor. A debtor is the person who borrows the money and who owes the debt. The debt is the amount of money. Collateral is the property of some sort that often is the security interest that secures the loan. And the security interest is the interest that is granted in that collateral in order to secure the debt and ensure that it's paid. Sometimes, of course, you could have an unsecured creditor who would be a creditor that doesn't have a security interest, but sometimes there is. The classic secured creditor, of course, is a bank that holds a mortgage on your property. That mortgage, that loan that's given to you, is secured by the property itself. So if creditors have a security interest, then they have the right to take possession of that collateral if there's been a default. And the terms of the agreement, the contract that's formed between the creditor and debtor, will define what constitutes a default as well as what constitutes an event that enables the creditor to actually take possession. And then once taking possession, the creditor will generally sell the asset and then take whatever money the creditor is owed. And then if the proceeds are insufficient, then the creditor still has a claim against the debtor. But if the proceeds are higher than what the creditor is owed, then the remaining funds obviously go to the debtor. If a creditor has a security interest in real property, then that interest is called a mortgage, as I just said. And when there's a default under the mortgage, the creditor's right to take possession is called a foreclosure, which again generally occurs through a judicial sale, and a court official sells the property, and the money then goes to the creditor, and then if there's any remaining money, it would go back to the debtor. Some statutes grant creditors the right to impose a lien, which means the right to hold a security interest on a debtor's property. So sometimes if one has a contractor working on property, that contractor will take out a lien on the property. So until you pay the contractor will have a security interest in the property itself. An unsecured creditor, on the other hand, does not have any rights to take possession of a debtor's property. Now let's look a little bit at how secured transactions work. Article 9 of the Uniform Commercial Code governs secured transactions. So in order to establish the security interest in the first place, there has to be an attachment. Without attachment, there's no enforcement. So the parties have to agree to create a security interest, which is known as a security agreement. The security agreement must be in writing. Why does it have to be in writing? The statute of frauds. Remember, we did that. So they have the security agreement. The creditor provides money or some form of consideration in return for the security interest, and the debtor must have rights in the collateral such that she can grant them to the creditor. Then the security interest is perfected, so the creditor files a financing statement, and that financing statement describes the collateral, describes the creditor's security interest, and it gives the creditor primacy in the event that the debtor goes bankrupt. The creditor has sort of first dibs on that secured property. Now, let's take a look at bankruptcy law. Federal law under the U.S. Bankruptcy Code governs bankruptcy proceedings, and such proceedings occur in federal bankruptcy court. And you could have a voluntary proceeding, which would be one that's initiated by the debtor, or an involuntary proceeding, which is one initiated by the creditor in order to obtain payment for debts. And the idea of the Bankruptcy Code is to have procedures for debtors to get protected from creditors and eliminate or reduce many of the debt obligations. And many debtors actually voluntarily file for bankruptcy so that they can be protected from a creditor's collection activity. And indeed, once a bankruptcy proceeding is initiated, a creditor may no longer seek to collect the debts outside of that proceeding. The filing of the bankruptcy petition itself creates an automatic stay, so all collection agency actions have to stop. Everything a collection agent might be doing have to stop, and everything goes back into the bankruptcy court to determine what the creditor is really going to get. Now, there are three primary forms of bankruptcy proceedings. There's a proceeding under Chapter 7 of the Bankruptcy Code, which liquidates the debtor's assets. Bankruptcy trustee is appointed to administer the liquidation process. The debtor transfers all of her assets to the trustee sells them and distributes them to the creditors, and the trustee makes the determination regarding the amount each creditor will be entitled to receive, but it's generally only a fraction of the debt that's actually owed. And the purpose here is to give debtors a fresh start so that they can get back on their feet and keep going without being constantly weighed down by an unsustainable debt load. On the other hand, it does mean that creditors only get a fraction of the debt, so we don't want debtors to just do this with impunity, so you can only do a Chapter 7 proceeding once in any given 8-year period. A creditor can also file a petition for bankruptcy under Chapter 11 of the Code, which provides for a supervised reorganization of a debtor's business. So under that proceeding, a debtor has to submit a reorganization plan to the bankruptcy court, which provides for termination or reduction of the debtor's debts. However, the creditors can actually submit competing plans for reorganization, and the court can then make a determination regarding what's the most efficient and feasible plan. And then finally, there's a proceeding under Chapter 13 of the Code, which enables debtors to create a repayment plan for certain debts. So debtors in this case retain their assets, unlike the other two chapters, but use the bankruptcy process to help them adjust their debts and develop a plan for repaying them over generally a longer period of time.